In a federal courtroom in Washington, D.C., a judge just dismantled the Justice Department's entire case against one of America's most powerful law enforcement figures. Not because the evidence was weak, not because the law changed, but because the people who brought the case had no legal authority to bring it at all. This is not a drill, and this is not a partisan headline. This is what happens when the machinery of American justice runs out of people who know how to run it, and the consequences reach far beyond any single case or any single person. If you care about whether your government can function, whether your courts mean anything, and whether the rule of law still holds in this country, what happened in that courtroom matters more than almost anything else happening right now. The Department of Justice has been the backbone of American law enforcement for over 150 years. It operates with a structure designed specifically to prevent one person, even the president, from turning prosecutorial power into a personal weapon. Career attorneys handle investigations with independence. Political appointees set broad priorities but are supposed to stay out of specific cases. Internal watchdog offices like the Office of Professional Responsibility exist to hold attorneys accountable when they cross ethical lines. This system is not perfect, but it creates something essential, a reasonable expectation that when the government puts someone on trial, it is because they broke the law, not because someone in power wanted them punished. That expectation is now under unprecedented strain, and the evidence is piling up in federal courthouses across the country. The most visible example involves the cases against former FBI Director James Comey and New York Attorney General Letitia James. Both cases collapsed in late 2025 after a series of self-inflicted mistakes that legal experts have described as almost unheard of in federal courtrooms. The prosecutor who brought both cases, Lindsay Halligan, was appointed by Attorney General Pam Bondi to serve as interim U.S. Attorney for the Middle District of Florida. But Judge Cameron McGowan Curry found that Halligan's appointment violated federal law, specifically the 120-day rule that limits how long an attorney general can appoint interim prosecutors before that power transfers to district court judges. Halligan's predecessor had already served 120 days, which means Bondi's appointment of Halligan came 4 months too late. Every single action Halligan took, including the indictments themselves, was ruled void from the start. The judge wrote that allowing such appointments would mean the government could send any private citizen off the street into a grand jury room to secure an indictment, as long as the Attorney General approved afterward. That cannot be the law, the judge concluded, and she was right. But the timing problem was only the beginning of the story. Court records show that Halligan signed a final indictment against Comey without ever showing it to the grand jury that was supposed to approve it. Grand juries are not passive bodies. They review evidence, they vote on charges, and they must formally approve any indictment before it becomes official. Halligan bypassed that step entirely. Ohio State law professor Rick Simmons, a recognized expert on grand jury procedure, reviewed the case and said he had never heard of anything like it. He described it as basic stuff that someone would learn very early in a legal career, mistakes that almost no one would make even if they were brand new to the office. Professor Andrew Leipold from the University of Illinois, who served on the federal committee that writes criminal procedure rules, asked a pointed question after reviewing the case. He wondered why Halligan was sent into the grand jury room entirely alone, with no experienced colleague to guide her. His question was simple and devastating. Does this mean that nobody in that office was either good enough or willing to go in with her? You could not have drawn this any worse for justice or any better for a defendant. Halligan also made fundamental errors in how she presented the case to the grand jury. A magistrate judge found that she misled jurors about constitutional rights, suggesting that Comey might have to testify to prove his innocence, and that jurors could assume there was more evidence than what was actually presented. These are not technical mistakes. They go to the heart of what a fair grand jury process is supposed to be. When prosecutors suggest that defendants must prove their innocence rather than the government proving guilt, the entire foundation of American criminal law shifts on its head. Halligan also relied on materials from Comey's own attorney without obtaining a new warrant, and she failed to filter out documents protected by attorney-client privilege. The cornerstone of the government's grand jury presentation, as one judge described it, was built on materials that should never have been used. The statute of limitations on Comey's case expired in September, which added another layer of difficulty. Because Halligan's indictment was void from the start, it never paused the clock the way a proper indictment would have. The case is effectively dead, and Attorney General Bondi has said she will appeal, but legal experts see little grounds for reversal. The appointment violation is clear, and the grand jury errors are documented. This is not a case that can be patched and retried. It is a case that was broken from the very beginning, and it collapsed because the people assigned to run it did not understand the basics of how criminal prosecution works. This is where the broader pattern becomes impossible to ignore. The Kamai and James cases did not fail in isolation. They failed as part of a systematic dismantling of the accountability structures that are supposed to keep the Justice Department functioning properly. Since January, the administration has fired or forced out approximately 5,500 career staff members from the department, according to Justice Connection, a group tracking these departures. Over 200 others were fired outright, according to the New York Times. The head of the Office of Professional Responsibility, the internal ethics watchdog, was ousted in the first weeks of the administration. At least 17 inspectors general across the federal government were fired within days of the president assuming office. The Council of the Inspectors General on Integrity and Efficiency was defunded. These are not random personnel changes. They are targeted removals of the people and institutions responsible for catching misconduct and reporting it honestly. Attorney General Bondi issued a policy requiring any DOJ attorney who refused to sign a brief or appear in court to defend the administration's actions to face discipline or termination. This eliminated the option for attorneys who had ethical concerns about a case to step aside rather than participate. They could either defend whatever the administration wanted or lose their jobs. The Merit Systems Protection Board, which protects career federal employees from arbitrary firing, had its leadership fired and demoted until it lost the quorum needed to function. Whistleblower channels were cut off by firing Special Counsel Hampton Dellinger, who handled reports of personnel misconduct. These moves did not happen in a vacuum. They happened because the administration was systematically removing the checks that kept prosecutors from being turned into political weapons. The Public Integrity Section of the Criminal Division, which historically investigated corruption by public officials, was gutted. Its staff was reduced from 36 lawyers to 2. The division that once pursued politicians who abused their power was left unable to pursue anyone. The Civil Rights Division, which enforces federal civil rights laws, lost roughly 70% of its career attorneys through reassignments and what the administration called deferred resignation offers. Leadership in that division openly described the staff as the president's shock troops against political opponents, a phrase that would be unimaginable under any previous administration. These are the people who are supposed to protect you when your rights are violated by the government. They have been pushed out, and the people who replaced them have been selected for loyalty above almost everything else. The results have shown up in courtrooms across the country. Federal judges have raised alarms about conduct by DOJ attorneys in a variety of cases. In one case, a judge found that the department's representations were so misleading that the court was left with little confidence that the defense could be trusted to tell the truth about anything. In another case, the judge concluded that the government had effectively forfeited the presumption of regularity, which is the default judicial assumption that the government is acting properly and honestly. That presumption has existed for decades as a practical matter, because courts have generally trusted that career prosecutors are following the rules. When judges start saying they can no longer extend that trust, the implications are enormous. Every filing from the department now faces extra scrutiny. Every representation must be independently verified. The efficiency that comes from assuming good faith has evaporated, and the system is slower, more adversarial, and more broken as a result. The attempted prosecution of 6 Democratic members of Congress illustrates the pattern in real time. The administration targeted Senators Mark Kelly and Alyssa Spotkin, and Representatives Jason Crow, Maggie Goodlander, Chris DeLuzio, and Chrissy Houlihan for a video that accurately told service members they do not have to obey unlawful orders. The video was a straightforward statement of black-letter military law. Service members have the legal right and sometimes the legal obligation to refuse orders that violate the Constitution or federal law. That is not sedition. That is literally how the system is designed to work. But the president publicly called the conduct seditious and demanded prosecution anyway. A D.C. grand jury refused to indict, which means a group of ordinary citizens looked at the evidence and said this is not a crime. The administration has not given up. and the lawmakers remain in legal and financial jeopardy. But the grand jury's refusal was a significant rejection of the legal theory behind the prosecution. These failed attempts do not exist in a legal vacuum. There is a statute called the Hyde Amendment, originally passed in 1997, that allows courts to make the government pay attorneys' fees for defendants who were acquitted in cases where the prosecution was vexatious, frivolous, or in bad faith. The bar is high. It is not enough that prosecutors made mistakes or even that they engaged in misconduct along the way. The case itself has to be fundamentally unjustified from the start. But the defining feature of this administration's Justice Department, as the Center for American Progress has documented, is not isolated misconduct. It is that targets have been identified first and legal theories have been built afterward. The president has publicly demanded prosecutions of specific political opponents and labeled them criminals in advance. Attorney General Bondi has repeatedly signaled that pursuing these cases was a priority, not because the law required it, but because the administration wanted it. When cases are brought not because evidence of a crime exists, but because someone in power wants someone punished, they look exactly like the kind of prosecutions the Hyde Amendment was designed to deter. If the administration continues pursuing these cases and loses them in court, the Hyde Amendment could become a real financial consequence. Courts would have to evaluate whether these prosecutions were rotten from beginning to end, not just whether they were handled badly. That analysis would require judges to look at the decision-making process, the political pressure, and the lack of independent legal judgment that went into bringing the charges. It would be an extraordinary reckoning for an administration that has presented itself as committed to law and order. But the more immediate damage is already done. The presumption of regularity is gone. The career attorneys who built institutional knowledge over decades are gone. The inspectors general who were supposed to catch wrongdoing are gone. The internal accountability mechanisms that kept the department functioning are gone. What remains is a Justice Department that is smaller, less experienced, more politically controlled, and less trusted by the courts it is supposed to work with. This matters to you even if you have never been involved in a federal case, even if you have never had reason to interact with the Justice Department, and even if you think this is all just politics that does not affect your daily life. The Justice Department is the reason that, when you hear about a corporation polluting a river, someone goes to prison. It is the reason that, when a police department violates constitutional rights systematically, there is an investigation and accountability. It is the reason that when a foreign government interferes in an American election, there is a prosecution. None of that works if the people running the department cannot make cases stick, if they do not understand basic legal procedures, if they are so afraid of the president that they will bring charges against anyone he names regardless of the evidence, or if the courts stop believing anything they say. The institutional capacity that makes federal law enforcement possible is not self-sustaining. It depends on people, on training, on independence, and on accountability. Remove those things and the capacity disappears, and it does not come back just because someone signs an executive order. The Kamai and James cases are not the only ones that have collapsed. They are the most visible, but they are part of a broader pattern that includes dozens of failed prosecutions, ignored court orders, and documented misconduct by department attorneys. Courts have demanded more verification of government filings, have questioned the credibility of DOJ representations, and have voided indictments that were brought by improperly appointed prosecutors. The administration has faced over 700 lawsuits since taking office, with courts ruling against its positions in the majority of cases that have been decided. Some judges have noted that the government has ignored at least 31 separate court orders. This is not a series of unrelated mistakes. This is what institutional collapse looks like when it happens in slow motion, one bad appointment at a time, one fired inspector general at a time, one career attorney who knows the law and the procedures replaced by someone who knows only how to follow orders. What happens next is not predetermined. Courts are beginning to push back in explicit ways, demanding better conduct and threatening consequences when they do not get it. Congress has oversight responsibilities that it can exercise if there is the political will. State attorneys general have filed cases that have had success in federal courts. Bar associations have the power to sanction attorneys who violate professional ethics rules, and some of the conduct documented in these cases appears to cross those lines. None of these responses are automatic, and none of them are guaranteed, but they represent the remaining mechanisms through which accountability can be enforced when the internal checks have been dismantled. The question is not whether the system is broken. The system is clearly broken in measurable, documented ways. The question is whether the people responsible for fixing it have the information they need to act. You have a role in this too. Not a dramatic one, not one that will make headlines, but a real one. The more people who understand what is happening to the institutions that are supposed to protect them, the harder it becomes for those institutions to be quietly hollowed out without anyone noticing. Share what you learn. Talk about it. Ask questions about why the cases that are supposed to prove the Justice Department is working are the ones that keep collapsing in court. The story of what is happening to American law enforcement is not a partisan argument. It is a structural crisis with real consequences for public safety, for civil rights, for the balance of power between the president and the courts, and for the basic question of whether the government can be held accountable when it overreaches. That story needs to be told accurately and completely, and you are part of the audience that can make sure it is. If this analysis has been useful to you, if you want to stay informed as this situation develops, and as courts issue more rulings on these matters, make sure you are subscribed to coverage that tracks the institutional details rather than just the political drama. The outcome of these cases will depend not on who wins the next news cycle, but on what the courts find, what the career attorneys document, and what the evidence shows. Keep watching, keep asking questions, and keep expecting the people who claim to support law and order to actually follow the law when it is inconvenient for them. The rule of law is not a slogan. It is a set of procedures, institutions, and norms that took generations to build, and that can be dismantled much faster than anyone expected. The collapse of the Kamai and James cases is not just a legal story. It is a warning sign about what happens when those procedures are ignored, when those institutions are gutted, and when those norms are abandoned in the pursuit of political revenge. Pay attention. The next case that collapses might be one that matters even more directly to your life, your community, and your rights. And by then, the question of whether the system can still function might be much harder to answer.